sharing your questions for estate planning. Here are the top 10 questions we have received. Please keep sending us more questions so that we can answer. No, estate planning is not about dying or accelerating death. It's about protecting yourself by healthcare directive, by financial power of attorney so that somebody can make decisions for you when you are not capable of. And yes, if you have any assets, then it should pass peacefully to your family and loved ones without any court hassles. No, your spouse cannot get everything automatically. You might have nominated your spouse on certain assets, but that does not somehow automatically communicate to other assets. So please make sure you have written a will or planned for all other assets so that they can pass peacefully to your family members. Once you're 18, your parents can't make decisions for you. So 18 is a good age to start thinking about having a healthcare directive and medical power of attorney. If you have family, assets, bank accounts, then it might also be a good idea to have a will. It's very important to create a revocable living trust if you have assets in multiple states, because just with a will or with no will, your assets needs to go through probate in each state they are in. So to avoid having lawsuits and probate process in each state, it's possible and it's doable through a trust. There are no set criteria on choosing a guardian. Depends, if it's a temporary guardian, then it has to be somebody who's closer, 30 to 1 hour away, so that they can take initial custody. But for permanent guardian, you need to make sure that they match your parenting style, that they share your values, and that you have confidence that they can treat your kids with kindness once you're gone. State taxes are based on the size of your state. So federal threshold is currently at 15 million, but Washington state threshold is at 3 million. So it depends on the value and the amount you have at the time of your death that estate tax would be decided. With the proper planning, you can defer and avoid estate taxes. Great question. Well, estate planning is not one and done. It needs to be updated as per your life situations and your life events. Any major events, you should look at your documents and reach out to your attorney to make changes and adjustments accordingly. Will and probate go hand in hand. So if you have written a will, it needs to be authenticated and verified by the court. This process is called probate. If you don't want to go through probate, talk to an attorney and plan your assets in a way that it can go through a trust, which will help you avoid probate. Planning is very important. Doesn't matter if you have a lot of assets or less assets. Planning helps you have decisions while you're alive, including a living will, which helps you make decisions of how long do you want any artificial care to be provided to you, because it's add to the expenses taken away from your estate, plus how you want those assets to be distributed to your family once you're gone, along with how decisions need to be made if you're in hospital for healthcare or for finances. So planning is not just about estate or wealth, it's also about life decisions. Will and trust. Such a sought after question. We have answered it multiple times, but here is the short answer. Will goes through probate. It's at least the bare minimum you need to have. Trust is a better option if you have parents overseas, family overseas, or you have beneficiaries in multiple states, or simply to avoid probate. So there is a lot of things you can do between will and trust, but at the bare minimum, you should have a will. Hope you liked the answers. If you have any questions, please drop them in the comments and we will reach out and answer them.